In this video, we are going to talk about the legal overview of charter schools. The first thing that we're going to talk about is the ways to authorize a charter school. There are 3 ways to authorize a charter school in Wisconsin under the Wisconsin Charter School Statute. The first is that a charter school can be authorized by a school district. When a school district authorizes a charter school, it authorizes the school either as an instrumentality or a non-instrumentality charter school. An instrumentality charter school is a school where all of the personnel of that charter school are employees of the school district. A non-instrumentality charter school is a charter school where the employees and personnel in the charter school are not district employees and in fact cannot be district employees. So whether a charter school is instrumentality or a non-instrumentality school, it is still authorized by a school district, but may be done one of those 2 ways. The second way a charter school can be authorized in Wisconsin is by one of the 2R entities that are listed in the statute. And you can see that under this slide. It's the Common Council of Milwaukee, the Chancellor of the University of Wisconsin System, technical colleges, the Waukesha County Executive, College of Menominee Nation, and the Lacouture Ojibwa Community College. Those are, we refer to them as 2R charter schools. And the third way, and really the most recent way that has come about in the Wisconsin statutes, is under the charter school law, under 2X of the charter school law. And under that provision, charter schools may be authorized by the University of Wisconsin's Office of Educational Opportunity. Those 2R and 2X charter schools are oftentimes referred to as independent charter schools. But please remember that that all charter schools in Wisconsin are public charter schools. They are public schools because they are funded with public taxation. So even though those schools, the 2R and the 2X, are referred to as independent charter schools, they are still public charter schools under the statute. Just in terms of talking about charter schools, I think it's important to kind of recognize the difference of charter schools and Wisconsin school districts. And to do that, just to give you kind of a basic overview of public schools in Wisconsin. The public school system operates within districts that are governed by locally elected school boards and superintendents, as you all know, throughout Wisconsin. In Wisconsin, we have 422 school districts. That number may be 423, but I think at latest count it's 422. And those school districts are created by statute and their authority is dictated by statute. Sections 115 to 121 are generally the statutes that are applicable to Wisconsin school district. There are others, but those are sort of considered the school district statutes. And in those statutes, you will find provisions relating to duties of the state superintendent, the CSAs and the cooperative service agencies. They'll talk about school finance, reorganization, school district governance, all of the issues I think that you would see in school districts. Those are all discussed and dealt with in those sections 115 to 121. Charter schools are also in those statutes. They're governed under 118.40 of the Wisconsin statutes. Like other public schools in a district, charter schools are public schools, as we said before, whether or not they're authorized by a school district, whether they're authorized by a 2R or a 2X. They are public schools, but they are run by generally a non-stock entity. So essentially a corporation that is organized under the laws of Wisconsin. Predominantly, it tends to be a corporation that's organized under the non-stock laws of Wisconsin, which means a nonprofit organization. They're run by that entity, which is referred to as a governance board, rather than the Board of Education of the school district. They are not subject, unless it's explicitly stated in the statutes, they are not subject to chapters 151 to 121 like school districts are. There are a number of provisions in those statutes that do apply to charter schools, but the general overall rule is that charter schools are exempt from chapters 115 to 121. What does it mean? It means charter schools have a lot more flexibility in terms of instruction, methods of instruction, their curriculum. their educational missions. It's what gives charter schools sort of that flexibility to be innovative in determining different ways to teach kids. We talked about the governance of the charter school just briefly. When the Charter School Governance Board incorporates as its own entity, and oftentimes will seek its own federal tax exempt status, it is now a non-stock or a corporate entity that governs and operates the school. That entity, when it is organized, has a set of bylaws that talks about how that governance board will run, who are going to be the directors, what is their fiscal year, how are they going to, how many directors are they going to have, how are they going to operate the board in terms of voting, committees, if there's compensation. All of those things are dealt with in the governance board's bylaws. The board may include, but it doesn't have to be limited to, parents or guardians of students and community members. Under the statutes, the statute says no more than a minority of the board's members can be employees of the charter school or employees or officers of the district or the authorizer. Schools, though, that receive federal grants, specifically if those schools are receiving federal funds, no members of that governance board may be employees or officers of the district or authorizer. As a general practical matter, it is, I would say, important to remember that in setting up your charter school governance board, if you are a charter school, you don't want a conflict of interest with members of your governance board and employees or officers of a district. So it's always, in terms of setting it up, it always makes sense to have your governance board be separate than your authorizer and not have those mix on your governance board. The purpose of the charter contract. So when you talk about a charter school, the charter school, as we said, can be authorized in one of those three ways. And I like to think about how that authorization is done is like a contract that is like any other legal contract between two entities. In this situation with charter schools, you have a school district as one entity and the governance board as the other entity. They enter into a binding legal charter contract that sets forth all of the important provisions that are necessary to know what type of charter school that's going to be and all the issues that go along with operating a school. So the charter contract, the purposes of it, it's to define the missions of the mission of the school, to identify what the instructional methods are going to be, to really clearly define the roles of the authorizer and the governance board, to delineate what the authority of the charter school governance board is, and to set forth the obligations of both parties. Whose obligation is it to provide special education? Whose obligation is it to provide IT services? How is that all going to be separated out? Those issues are dealt with in the charter contract. A well-drafted charter contract can protect both the authorizer and the governance board by putting provisions in there that make it very clear what both the authority and obligations are of both parties. Also to develop procedures for evaluation, so an authorizer can evaluate the charter school. Revocation in the event that an issue comes up and the authorizer or the governance board needs to revoke the charter contract, and what happens if the school closes. The model contract, which you have probably seen on the Works site, those model contracts are just that. They are just a model template for a place to start when you are drafting a contract for your charter school with their authorizer. They are not mandatory contracts. They do set out in the contract, though, all the required statutory provisions that you're required to have. And then they also set out that the model contract also sets out provisions which I would encourage you to consider and to possibly talk about with your authorizer and in your governance board to determine if you should have those provisions in there and how you will deal with the issues that those provisions address. Those provisions have the ability to make your contract stronger so that you know what those authorities and obligations are. But the model contract is just that. It's a model. It can be modified, it can be amended, it can be tweaked, it can be changed. You don't have to start with it. But if you are certainly starting from scratch, or if you're starting from a contract that was drafted 10 years ago, it can be a very helpful place to start. There are also benchmarks on the work site, and those benchmarks are what DPI will use to determine whether or not your contract has the required provisions in it. So those benchmarks will help you identify what's required in your contract, what you might want to consider, what may be necessary for virtual charter schools, consortium charter schools. So those benchmarks are important for you to look at and use as you draft your charter contract to make sure you have the necessary provisions in your contract.